Well, that the picture was based upon an Associated Press photograph.
I understand. Well, good afternoon. You've come in kind of halfway into discussion between the amazing Professor Matthew Rimmel from, and I'm going to read this out so that I get it completely right. Matthew is the Professor of Intellectual Property and Innovation Law at QUT Faculty of Business and Law. Thank you so much for joining us today, Matthew. And Matthew and I have been discussing everything innovation and all things intellectual property, and we've been going for a couple of minutes, maybe 10 minutes or so, and then we realized that it's already after 1. So here we are. My name is Elise Hatton. I'm the Smart Hub Business Manager. Welcome to today's Hub Live. We are going to have a fantastic discussion around intellectual property today. I met Matthew a few weeks ago, and he's extremely knowledgeable and has a really interesting take on intellectual property. And what we're going to do today, or we're going to navigate the way in which you as a business owner can think about what you have, the intellectual property that you potentially have in your business, and how to protect that property, and what the advantages and disadvantages are, and really also looking at, you know, how the intellectual property laws really do not favor the small players, but in a way protect the people with deep pockets, which often are not our startups and our SMEs. So hello, Matthew, how are you?
Good, thank you. I've been doing a bit of field work over the past month. I'm visiting Central Queensland and North Queensland and the Northern Territory, looking at some regional innovation. So it was wonderful to visit your Smart Hub, and I was kind of very impressed with your physical presence and your virtual presence and the work that you've been doing in this field. And it was certainly an education for me to see the evolution of various different innovation structures in regional Queensland and the Northern Territory over the past month. In many ways, I was a little bit surprised about how well established some of the structures have been over the last few years. So obviously there's been a lot of investment by local government and the state government and the federal government in terms of some of these facilities in the area.
Yeah, well, we've certainly been invested in by, and we are owned by Rockhampton Regional Council, and I think it's a very visionary for our council to have a facility such as a Smart Hub, and it's been very beneficial for our community. Hey, Gina, thank you so much for joining us today. If you have any intellectual property questions for Matthew, please feel free to pop those in the chat in Facebook, and we will be sure to get back to you with an answer. So tell us just a little bit about your background, Matthew. How did you come to be interested in intellectual property?
Well, my interest in intellectual property really stemmed from when I was an undergraduate student. I was doing law and I was doing literature and a bit of psychology as well. I had a very good lecturer at the time who did work on intellectual property, and I could really see the connections between some of the legal areas that I was studying and some of the cultural areas that I've done work on. Since I got my PhD back in 2001, so a couple of decades ago now, I've really been expanding my interest in intellectual property across a range of different sectors. So my interests have been a little bit eclectic, but you know, I've done work on digital copyright. I did a lot of work on agriculture and intellectual property, and biotech and intellectual property. I've done a lot of health-based work on access to medicines and plain packaging of tobacco products. I've been very interested in the next industrial revolution and the way that that is affecting innovation. So we're very interested in 3D printing and robotics and the Internet of Things at QT. Done a lot of work around intellectual property and sustainable development, and a fair amount of work around intellectual property and climate change. There's a lot of trade-based issues associated with intellectual property as well. And I guess finally, I've also been quite interested in the area of Indigenous intellectual property. So over the past 2 decades, my work has spanned a number of different fields and domains. So I'm sure I've covered something that will be of interest to your viewers one way or another.
Oh, absolutely. Hence why we have you as our guest today. We really do appreciate you sharing your expertise and years of experience in this field. So let's start. Last week, we had a very interesting, or not last week, a couple of weeks ago, we had a very interesting Hub Live where we brought together 5 of our members, and they each represented a different kind of business in our ecosystem. And so we had a micro business owner, we had a budding entrepreneur, we had someone with a startup, and really when I say the word startup, I don't mean an early stage or starting company. What I mean is a high growth, highly scalable company. We also had a small SME, and we also had someone from a big corporate join us. And really, all these different kinds of businesses have different intellectual property within their businesses, and different trajectories, don't they? Can you talk to me a little bit about, depending on where you are in your business journey, what should you be looking out for and what should you be doing as a business owner?
Okay, I think it'd be useful perhaps to kind of unpack some of the different varieties of intellectual property, and then talk about how they might be of relevance to certain sorts of businesses. So, intellectual property really refers to a cluster of legal disciplines. Some of those disciplines are focused on kind of quite cultural forms of production. Other forms are much more centered around scientific inventions. And there is certainly a kind of a discipline as well that is much more focused upon marketing and branding. So I think as a first step, it would be useful just to give some quick definitions for some different kinds of intellectual property. So copyright law really relates to a bundle of economic rights, most notably the right to copy, the right of reproduction, and a cluster of moral rights, the right of attribution, the right of integrity, the right to object to false attribution. Copyright relates to cultural works like literary works, artistic works, dramatic works, musical works, television and radio broadcasts, films, published editions, and certain other things like computer programs as well. Copyright law provides very long protection. So for traditional works, it's life plus 70 years now in Australia and many other jurisdictions. Few jurisdictions still have life plus 50 years.
So can I just ask, when you say life, do you mean the life of the person who created the work?
Life of the author, if there's an author.
Yeah.
For if there's a kind of a corporate entity, like for other subject matter, it's normally 70 years from the moment that the work is distributed. So copyright law provides very long protection. There's no requirement for registration anymore in relation to copyright. So it's automatically created as long as your work is original and fixed in material form. Nonetheless, we often rely upon entities like copyright collecting societies to manage rights in relation to copyright. Copyright is subject to defences, like the defence of fair dealing in Australia, the defence of fair use in the United States. There are special exceptions for libraries and archives and cultural institutions and various other things as well. But I guess copyright law is a very big domain of intellectual property, and particularly noticeable in relation to music, film, publishing, artwork, and development of computer software. So that's one of the big domains of intellectual property.
Right.
Another big domain is trademark law. Trademark law is a registration system. So in order to kind of get protection for a trademark, you have to have it registered at the trademark office. You have to establish it has inherent or acquired distinctiveness. Signs can be traditional things like logos and names, but you can also have trademarks in relation to colours and scents and sounds. So the roar of a Harley Davidson, for instance, or a particular colour for a product. But you have to kind of establish that the work is distinctive. Trademarks provide protection as long as the mark is distinctive. So trademarks can die, and that is called genericide. So sometimes trademarks become generic. So think about, for instance, laser or windsurfer. Those are once trade names that have since become generic. So trademark holders have to ensure that their work remains distinctive. The third big field of intellectual property is patent law. Patent law provides exclusive rights to exploit an invention. It's a registration system. You have to establish that a patent application is novel, inventive, and useful at the time it was filed compared to the prior art. And the prior art consists of patents already on the register and other commercial inventions that are out there. Patent law provides very strong protection in relation to invention, but it provides a shorter term, 20 years of protection than, say, copyright law. Patent law has certain exceptions and defences around experimental use and compulsory licensing and crown use. Patents are a very important area of intellectual property. In addition to those major fields, I guess we have a number of smaller forms of intellectual property as well. We have a regime for industrial designs, which is a registration system. We have a plant breeders' rights regime for plant breeders' rights. We have a special regime for geographical indications for wine and other alcoholic beverages, where there's a connection between a region and a product. Increasingly, the domain of confidential information is really important. So there is stronger protection in relation to trade secrets, with not only civil remedies, but also criminal offences being created, particularly to deal with state-sponsored hacking. And there's, I guess, some adjacent fields that are quite relevant to intellectual property as well. So consumer law kind of plays a really important role in reinforcing the trademark system. You can kind of take action in relation to misleading and deceptive conduct under consumer law, and that's often really helpful. In addition to trademark law, you have some common law actions like kind of passing off as well. And there are a few other bits and pieces of other sui generis, one-of-a-kind systems, like there's a Circuit Layouts Act, for instance. There's a bit of discussion about whether personality rights should be protected under intellectual property. So it's a real kind of jumble of different disciplines. And I guess that's a quick overview of intellectual property, but to go to the part of your question about, well, how do different entities and different firms make use of these regimes? Well, you have to think across these different disciplines and think about whether or not they're relevant to your business or the technology that you're involved with. And sometimes it will involve combinations across those areas. So it's very contingent upon what kind of area of business you're involved in, because often intellectual property operates very contextually in different sectors or in different fields. And sometimes there are very special considerations in terms of particular areas and particular fields. So IT and biotech and access to medicines and clean tech all have their own little kind of cluster of precedents and litigation and traditions in terms of how the law works in those areas.
Wow. Okay, so it's complicated is I think a summary of what you said.
I think there's a range of different forms of intellectual property, and I think it's really important to identify any potential intellectual property by your business. So you have the freedom to make choices about what you want to do with that intellectual property. And sometimes that's really kind of critically important for certain regimes. So if you are developing a scientific invention, for instance, you don't want to publish that or talk about it at a conference before you filed your patent application. You don't want to inadvertently disclose it. So for some of the industrial forms of intellectual property, you do need to just be careful that you protect their confidentiality before you go down the route of publication. But if you can identify a new potential form of innovation early on, you can, and then disclose it, you can then think about how best you might manage it. So even at a university like QUT, where I'm based, we have an intellectual property policy. One of the key things in that policy is getting staff to disclose any intellectual property that they might generate, just so the university can then think about what is the best way to go down dealing with that intellectual property. Sometimes you make the choice that you protect it and control it. Sometimes you make the choice of dedicating it to the public domain. Sometimes you openly license it. But you have the most freedom if you can kind of identify the intellectual property at an early stage and then work out what your business strategy or your technology strategy might be in relation to that particular form of innovation.
Okay, that makes a lot of sense. Hello, Brad, Charlene. Thank you so much for joining us on today's Hub Live. I'm here with Professor Matthew Rimmer, and he is talking to us about all things intellectual property, has many, many years of experience in this field. And if you have any questions, please feel free to put those in the chats and we'll be sure to get those answered for you. Right, so how do you identify if you have intellectual property? That's kind of the broad question that I have to ask, but then just a couple of things that I think will be really relevant is, so in terms of your logo and your name and your, should we be thinking about trademarking those? The second question is, if you come up with a new idea, what do you do with that? Are you able to talk about it? Because some things that, you know, I'm always trying to encourage people to be more open with their ideas, and you're saying, oh, maybe, you know, you should be a bit more cautious. Can you talk to us about that? And then the third thing is coding. Specifically, what do we do with that? Is that patentable? Okay, but start with trademarks and logos first and just identify.
Well, trademarks kind of play a really important role in relation to identifying a business, communicating with consumers. Trademarks are also meant to kind of promote kind of competition in a marketplace. You know, the key thing, as I said before, is that a trademark has to be distinctive. And there is a register of trademarks. So the immediately challenging thing about a trademark is that you have to go through the register and work out how you can devise a trademark that won't be confused with any other trademark on the register. Trademarks often work in relation to certain goods and services. So you have to kind of work out in what fields will the trademark operate. In certain fields and disciplines, trademark law has been kind of critically important. You know, trademarks often kind of create barriers to entry to new competitors. Trademarks have sometimes been used also for the purposes of brand extension. So well-known trademarks or famous trademarks get additional protection. If you kind of have a think about some of the big global trademarks, like say the Nike swoosh or the Apple, you know, trademarks kind of play a really significant and important role for the brand identity for those companies, but they also kind of give them the ability to bring action for infringement against anyone who has borrowed or copied that logo design without permission. There are other things that you can rely upon as well as trademark law, as in addition to trademark law. So as I said before, consumer law is becoming increasingly important to deal with misleading deceptive representations, but also the common law doctrine of passing off is really kind of important. To stop people passing off your identity. There's certain sectors, I guess, in which trademarks are kind of particularly important. So I know that you have a background in fashion, and it's certainly an area in which trademarks kind of play a really significant role in terms of distinguishing between different products in the marketplace, and trademarks are kind of used very heavily. We've also seen in the food sector lots of trademark fights breaking out of late between fast food stores over the branding for burgers of one kind or another.
Yeah, they are very similar. The naming, I find it very, very amusing to look at the way in which the fast food people are branding their burgers.
And, you know, sometimes there are challenges there as well. So there's been a lot of controversy over the big supermarkets engaging in private labeling as well. I mean, many food manufacturers have kind of complained that Coles and Woolworths have been using branding that has been similar to theirs, and they have found that kind of problematic. So trademark law is a really immensely important field of intellectual property, and perhaps doesn't get the attention that it deserves. But in some ways, it can also be a very kind of long-standing form of protection, because once a patent has expired, or even after copyright has expired, you can still rely upon trademark protection. So Disney, for instance, uses the Disney brand even on copyright works that have fallen into the public domain. Pharmaceutical drug companies often still try to rely upon a trademark brand name even when their patent has expired and they're facing generic competition. So branding and marketing is really important in terms of that sphere. And as I said before, sometimes we have some very specialist forms of intellectual property protection in relation to branding. So geographical indications in Australia extend to wine. So for instance, the region of Coonawarra or the Hunter Valley. There are special rules in relation to only winemakers from those regions can use that term. The European Union has been pushing for Australia to expand geographical indications to foodstuffs as well. So that might be a particularly pressing issue for Rockhampton, given the interest in the beef industry. That there might be some concern about an expansionist approach for geographical indications by the European Union in terms of some of the current trade arrangements. Sometimes also we kind of create special regimes for insignia for particular events. So for the Commonwealth Games and the Olympic Games, they had special legislation protecting the Commonwealth insignia and the Olympics insignia as well. And we also, internet domain names, I guess, is another related area. Trademarks often work alongside internet domain names. We have now arbitration and mediation systems set up under ICANN to deal with disputes over internet domain names, but they're becoming increasingly important as well.
Interesting. Okay. Hello, Tammy. Hello, Michael. Thank you so much for joining us. And I have a question from Brad. So I'm just going to interrupt our current answering of our questions to ask Brad's question. Does a confidentiality agreement typically stand up in a court of law and to protect an organization's IP?
Yeah, that's a really good question. So there are a variety of different ways that you can protect confidential information. I mean, in Australia, there's a common law doctrine, so you can rely upon that. But you can also kind of rely upon contracts and agreements in relation to confidential information. As I said before, there's been a bit of a revolution in relation to the protection of trade secrets. There's been a push for the greater use of criminal penalties and procedures. So not only do you have civil remedies, but you also have criminal offences now in Australia where trade secrets theft is directed by a foreign principal. So say, for instance, a foreign government hacked a university and took their intellectual property, that would raise issues in terms of a criminal offence in relation to trade secrets. I think that's important to remember the scope of the operation of trade secrets. It's not necessarily dependent upon the existence of an agreement or a contract in all circumstances. So you can have situations in which third parties take trade secrets and it still amounts to a breach of trade secrets. There is still debate about what information should be considered to be confidential and what information is in the public domain. Former Prime Minister Malcolm Turnbull was actually involved in one of the key precedents in Australia involving an autobiography called Spycatcher. And in that particular dispute, the UK government tried to argue that the autobiography was confidential, contained confidential information, but Malcolm Turnbull was able to establish and prove that really that information had already entered into the public domain. So what is confidential remains a critical issue. There's an ongoing debate about what defences are available in Australia. Some judges argue that there should be a general public interest defence, like Justice Michael Kirby. Others, like Justice Gummo, have argued the defence should be limited to circumstances of iniquity. Confidential information is becoming increasingly significant in a range of different sectors because it's often used as a preliminary step before getting other forms of intellectual property protection. You might have seen the massive dispute that took place between Google and Uber. Anthony Lewandowski, an engineer, left Waymo, Google's self-driving car project, went to Uber and allegedly took with him lots of confidential information about the self-driving car project. Google sued for breach of trade secrets and patent infringement. Uber settled. Google took arbitration action successfully against Lewandowski. Then the US Department of Justice took a criminal action against Lewandowski, which was successful. One of the quirks of the US system is that the president is able to give pardons. Lewandowski got a pardon from President Trump as President Trump left. But increasingly in a range of different sectors, we see a heightened use of trade secrets in relation to IT and biotech and agriculture and medicine. Do agreements always hold up in court? Not always. Sometimes there's been a bit of controversy about overreaching agreements that try to have onerous terms and conditions, particularly on former employees, which kind of prevents them from engaging in employment or further employment. So there has been a bit of discussion about restraint of trade and the limits to contracting. It's also been a big issue in relation to sexual harassment. So sexual harassers like Harvey Weinstein, for instance, have allegedly used non-disclosure agreements to try to cover up instances of sexual harassment and sexual assault. And I think courts are really pushing it back against the abusive use of non-disclosure agreements in those contexts. So it's a very volatile and dynamic field at the moment, what's happening in relation to confidential information and trade secrets. And as Elise kind of pointed out, there's real tensions there. Some commentators like Orly Labelle, for instance, say there are dangers if you have overprotection of trade secrets and confidential information. It means that people do not share ideas, collaborate and cooperate. She argues that the US innovative strength in Silicon Valley was dependent upon the mobility of labor and people moving from company to company and taking their knowledge and ideas with them. So there have been some critics of overprotection of trade secrets who say that, if you lock everything down, that might inhibit creative collaboration in various different ways. So there's quite
an
a
overall
dynamic
progress
at the moment about protecting confidential information versus open collaboration and open cooperation.
Yeah, that makes a lot of sense.
Mm.
Brad, I hope we answered your question. If you have any other questions or if you would like further clarification, just please let us know in the chat. Okay, so back to the previous kind of question, how do we know as business owners in Rockhampton what we have to protect? What and whether it's worth the cost and the effort to actually protect. One thing that I've always thought is if you can't enforce, even if you have something patented or copyrighted and you don't have the resources to enforce that or to take someone to court or to afford a lawyer, does it even help to do that in the first place? Can you give us a bit of practical hands-on advice as to what to do as business owners?
There are certain regimes of intellectual property that don't require registration. So copyright law, confidential information, the common law of passing off can be relied upon without the need for registration, and there's no registration costs. So in terms of their accessibility, those regimes of intellectual property are quite easy to use as a result. The registration systems are more complicated and expensive. They have examination processes. If you want to kind of get protection for a trademark or design or patent or plant breeders' rights, you have to satisfy threshold requirements. They're often dependent upon what else is the prior art. So you really have to demonstrate that you are doing something that's not already on the register. But there are also kind of costs involved. Registration has to be on a country by country basis. There are some procedural mechanisms that help you get protection across multiple jurisdictions, but it's not always the case that the same person holds the rights to the same invention jurisdiction by jurisdiction. Sometimes you can have quite split outcomes. So that is a complicated issue for startups and small to medium businesses, independent inventors, in terms of how do they use their money. And often there are difficult economic questions there about, how much money do you spend on intellectual property registration? How will you deal with intellectual property enforcement matters? How will you deal with intellectual property licensing matters? Does it make better sense to invest your money in other ways? What are the dangers if you don't get some sort of form of registered intellectual property? Well, there are certainly dangers in the sense of there are many large, well-established companies in the marketplace who have webs of patents around their products and rely upon a portfolio of trademarks and designs and other forms of intellectual property protection. Sometimes they take intellectual property action against competitors and rivals, even perceived small ones. So the danger of having no intellectual property is that you might then be vulnerable to attack, or you might be vulnerable to another business engaging in copycat activities against your business and adopting a very similar business model. So not seeking out registered intellectual property protection does come with certain risks. But there are also kind of risks associated with going down the route of taking out intellectual property protection. It's one thing to have a registered patent or a registered trademark or a registered design, but you still need to work on your business model about how are you going to use that particular registered intellectual property. How are you going to license it? How are you going to exploit it? I guess it's also really important for businesses to think about how others are using the intellectual property regime. So when I visited the Smart Hub the week before Beef Week, I was having a chat to Elise and talking about one of the big cases in the Australian legal system over patents and biotechnology, and that involved Meat and Livestock Australia opposing patents by Brandhaven in relation to the bovine genome, so kind of genetic patents. Unfortunately, they were not successful in invalidating the patents by this US biotechnology company, but their concern was that this US biotechnology company could then kind of control downstream applications, including in relation to food, for the exploitation of the bovine genome. So sometimes you have to kind of think about what other patents you might cut across or you might use yourself. You have to think about it. Not only are you a potential applicant, but you might be a potential infringer. So you have to be kind of careful about what other parties do. Sometimes you have to think about licensing to kind of get a license to get permission to use another invention or another form of registered IP. Sometimes there are opportunities in terms of acquisition of intellectual property. So I visited Central Queensland Uni, which has a big new advanced manufacturing hub. And there are many other advanced manufacturing hubs being set up in Northern Queensland as well. There might be opportunities there with the university or one of those hubs creating a new invention which you could get the rights to or buy or acquire that particular product. So I guess that's worthwhile thinking as well. You don't necessarily have to invent everything yourself. Sometimes there might be opportunities in terms of intellectual property that you can acquire or license. So sometimes very powerful corporate entities are built out of strategic acquisitions and licensing of key forms of intellectual property.
I think you touched on a very, very important point there, and that is for people who are just trying to get stuff done, then you can easily really use someone else's work on which there would be copyright. And I'm thinking of website terms and conditions. I'm thinking of photos on the internet that you can just borrow and put on your website. That's very dangerous territory and should be avoided. You shouldn't borrow other people's copyright information off the internet. That'll get you into trouble.
Well, you do need to kind of work out the source and origin of material. And, you know, copyright law is very kind of broad ranging in terms of the things that it covers. In copyright law, you can kind of argue that something is independently created. So that's kind of significant. But sometimes it can be very expensive. So Clive Palmer, the mining magnate, learnt that to his cost when he decided that he wouldn't license the music from Twisted Sister about We're Not Going to Take It anymore, and instead kind of did his own pastiche of that musical work. And the federal court have fined him millions of dollars for infringing that copyright. So it can be kind of quite expensive if you don't take those issues seriously. But sometimes there's a question about kind of working out who is the owner of a work if you want to kind of get a license. But sometimes you can think about defences as well. Sometimes defences might work as well. So yeah, you do need to kind of think about those issues as you're kind of developing your own work. Patent law is even more tricky in the sense of a patent can be used for patent infringement action, even if someone independently comes up with the same invention. So it's no defense under patent law to say, I was merely an innocent bystander, I didn't know the existence of this patent. Patent law kind of provides very strong protection in relation to the use of patent inventions. So, you know, there is a patent register, but it can be very tricky to work out what is on the patent register and what might be relevant to the work that you're doing. So that can be kind of quite challenging as well. And trademark law has its own challenges as well because the trademark register is so cluttered. There's very little space left in terms of what is on the trademark register. So that makes it challenging in terms of branding and marketing products as well.
Yeah. Well, to be honest, I feel like we have but scratched the surface of this topic. There is so much that we can still discuss, and it is a wide subject. It touches every business owner on some level. And so I want to invite people to contact us at the Smart Hub because I have some really, really exciting news. And that is that Professor Matthew Rimmer has agreed to be one of our mentors. And so if you have specific questions that you want to ask in relation to any intellectual property or even innovation law regarding your business, the best way to get in contact with Matthew is to contact us, and then we will put you in contact with him for a mentoring session around IP and IP protection. And I think the one thing that is very obvious to me is that it's quite a maze of different options and different registers and different processes, and so every business is probably a little bit different depending on your industry, depending on where you are, depending on your goals and ambitions. So a business who person who is starting a lifestyle business and never has great aspirations to become a global company would have different requirements to someone who is starting out, and they look probably very similar at the start, but to someone who wants to, you know, be a global dominant player, they have different requirements again. And so I think every person's situation would also dictate the advice that, or the direction that you would guide them in. Is that true?
My small disclaimer would be I'm not a practicing lawyer, so I don't give specific legal advice. I'm an academic innovation lawyer. In other words, I'm kind of interested in terms of promoting literacy in relation to intellectual property. But there are certain specialists you can see as well to kind of get specific legal advice. There are specific professions dealing with the patent regime. So you need a patent attorney to kind of draft a patent. There are also trademark attorneys to deal with the trademark regime. There are some other specialists in relation to designs and plant breeders' rights. And there are different forms of specialist lawyers as well who deal with different forms of intellectual property and licensing and enforcement. I guess I am here in terms of a mentoring role to kind of pass on some knowledge from my kind of academic research and help translate that to the Smart Hub. And hopefully that will be helpful and useful. But it is really important to boost your legal literacy as well as your business literacy, particularly in the areas that are pertinent to the area of technology or the business that you're working in. Because often it's a very competitive marketplace. You kind of need to work out how you can situate yourself in that field, and you have to kind of grapple with some of these kind of questions. And I hope through education that we can boost Australian entrepreneurs' knowledge about some of these issues so they're not kind of taken unawares or surprised by what might happen in terms of the legal arena. So I think that's kind of really an important role of the Smart Hub in terms of boosting our collective understanding of, you know, the law and the business behind the various different technological innovative work that we do.
Absolutely. And you make very good points, and I absolutely agree with them all. So just before we finish, I have one last question that I asked before. What about coding? Like, what about actual code? Is that patentable? What do we do in this area? If you're developing software, what do you do?
That's a good question, and it's a contentious question in many ways. Historically, you know, when I was a student, there are still debates going on in terms of intellectual property about whether or not we should create some new field of intellectual property to deal with software and hardware, or whether we should use some of the existing regimes. And in the end, we've kind of used some of the existing regimes, even though it has been quite awkward. So copyright law in Australia defines literary works as including computer programs, but sometimes the schema of copyright law don't translate very well for coding. We just had a big dispute in the Supreme Court of the United States involving Google and Oracle, which Google won on the basis that what they were doing should be protected in terms of interoperability under the Defence of Fair Use. But it was certainly a long-running piece of litigation that highlighted some of the complexities involved with complying copyright law to coding. The free software movement and the open source movement really have rebelled against that approach and used open licensing to put code into the public domain. And the Creative Commons movement has kind of taken that further. The patent regime has certainly had challenges in terms of how it deals with computer programs. Once upon a time, patentable subject matter was not meant to deal with mathematical algorithms, But really, since the 1990s, there have been patents granted in relation to business methods and applications of algorithms for things like computer programs. The courts, though, have pushed back a little bit of late about what patents satisfy the criteria for patentable subject matter. So there's a Supreme Court of the United States decision in Alice, which kind of took a tougher stance against patents in relation to business methods and software. And there's been some Australian federal court action that has pushed back against patents in respect of, obvious business systems. So someone kind of had a method of protecting a trust, and that was rejected as merely being an idea rather than an invention. But it should be noted that, other forms of intellectual property are heavily used by the IT sector. So trademarks are critically important. We kind of think about how trademarks operate in relation to IT. But increasingly, confidential information is being used really heavily by some of the big IT companies. So Apple in particular have been very jealously protective of their trade secrets. So to answer your question, in some ways we have a mishmash of different forms of intellectual property being deployed in that sector, as well as the odd specialist regime like circuit layouts. But there remains a huge tension between proprietary models of intellectual property in relation to coding and movements calling for free software, open source licensing, and Creative Commons style modes of sharing code. So there still is a very stark schism within the sector about what is the best way to deal with intellectual property. And it's still a very dynamic situation in terms of how the courts deal with applying intellectual property to coding.
Okay, I understand. It's
well, it's the intellectual property system sometimes struggles to accommodate new technologies. And
yes.
that's certainly been the case in relation to coding. I mean, you think about copyright law as being created to deal with literary works, doesn't adapt very well to deal with coding. Patent law was really kind of invented and took on its main kind of structure during the Industrial Revolution and was designed for mechanical inventions. There have been difficulties in translating how the system works to then deal with information technology. And I guess even though it's been a number of decades since the IT revolution started to really affect business in many different ways, the legal system is still struggling to work out how to strike the right balance in terms of the interests and rights of developers and the concerns of users. And really the sector is very kind of divided as well in terms of proprietary versus open approaches to coding. But it's certainly the case that there have been some very successful open source companies developed that don't go down the proprietary approach. I mean, you think about Red Hat, for instance. I've been doing a lot of work in relation to 3D printing and additive manufacturing, and it's noticeable that the Czech company Prasa has been very successful following an open source model. So certain models of open innovation have been successful with the right business models as well. So it's a really interesting sector to think about and look at as well.
It looks like they might, I don't know, it looks like it might be better under its own regime, really, because it's complicated.
Well, I think there are always certain fields of technology that awkwardly sit across the existing regimes of intellectual property. And sometimes you have to kind of work out how those systems operate. But, we're talking a little bit about food and fashion before. Fashion is certainly one of those areas that doesn't easily fit into some of the existing categories of intellectual property.
Mm.
And food has been a little bit complicated as well. You know, patent law wasn't traditionally meant to apply to food, but increasingly the subject matter has expanded to include food science. But those fields are curious because they often rely upon imitation as well. So it's quite a complicated set of norms at work in some industries as well. So I think thinking about the context or the field that you're working in is critically important in relation to intellectual property, because sometimes some very specific rules have been developed in relation to particular contexts, and sometimes there are controlling precedents in certain areas as well.
Makes a lot of sense. Well, I think, can you believe we've been going for 53 minutes? This has been a wonderful discussion. Thank you so much, Professor Matthew. It's been wonderful chatting with you and getting a better picture and a better handle on intellectual property. If you would like to have a chat directly with Matthew, please feel free to reach out to us here at the Smart Hub. You can do so either through private messaging us on Facebook, or you can email us at smarthub@rrc.qld.gov.au. There will be no Hub Live in a couple of weeks. We've been testing this fortnightly Hub Live session, but 2 weeks from today is a public holiday here in Rocky, and so we won't have a Hub Live on that day, but we'll be back in 2 weeks after that. So we'll see you back here in a month's time for our next Hub Live. Hope you have a good month, and we look forward to seeing you then. Thank you so much, Matthew. Really appreciate your time.
Thank you very much. It's been a pleasure to be part of your very dynamic and vibrant Smart Hub series. I look forward to seeing how the Smart Hub grows and evolves over the years. So thank you kindly.
Thank you so much for being part of that journey with us. We really appreciate it. Thank you. Thank you. Awesome. See you next time.